application of Imam against the Borough of Croydon.
Yes, my Lords. Yesterday I was in the process of going through submissions on where the parliamentary balance have been drawn, and I was about to start on the balance between Part 6 and Part 7. What I propose to do this morning is deal with that, I hope, briefly, because I can do it by reference to the text we passed up. I will then come on to deal with some submissions about the relevance of resources and making short observations on impossibility and the position of third parties before I come on to deal with the Court of Appeal decision and the particular points that arise out of that.
Yes.
So dealing with Part 6 and Part 7, Part 6 deals with a wholly different process from that of provision for the homeless, because it deals with allocating housing accommodation, secure tenancies and nominations, in effect. And as has been noted on many occasions, Part 7 and Part 6 are separate, and it's important not to confuse the two. In particular, the Court of Appeal in this case, paragraph 144 at page 267 of the bundle, referring to Ali and the statement of Baroness Hale there. If an authority do allocate, then Parliament has created the reasonable preference categories, which have a long history, but until 1996, the reasonable preference duty was expressed in general terms. As Mr. Rutledge pointed out yesterday, the 1977 Act added the homeless to the reasonable preference group. It didn't require them to be given housing, but only a reasonable preference. But as the Act came to be understood, the provision of the full housing duty was often fulfilled in that way because of the understanding that that accommodation had to be settled or permanent. That wasn't in fact the case, as Lord Hoffman pointed out in a word, but I don't need to go into that. In 1980, security of tenure was introduced to council tenancies, and that introduced secure tenancies. There were exclusions from security where local authority accommodation had been used to discharge homelessness functions, but it was limited to when it was in discharge of interim or temporary duties, and then for 12 months grace period thereafter. The provision that I don't need to ask you to go to was Schedule 3.5 of the Housing Act 1980, which is in the bundle at 547. So unless that exclusion applied, if an authority used its own stock after a decision on the final duty, they create a secure tenancy. And that's the background to the 1996 Act, and the structure created by that Act was part of a design to counter concerns that the balance between the homeless and others hadn't been properly struck. And if I can take you, for these purposes, to the text that we emailed to the court, Arden and Bates on homelessness and allocations. I hope you have it.
It's the one we had this morning?
No, it's the one, it came on Friday.
Yes.
And if I can ask you to go to page 20 of that, just to give you the heading, which is Housing Act 1996, Parts 6 and 7. And we see from 1.71 that it was foreshadowed by a consultation paper, Access to Local Authority and Housing Association Tenancies, and that was published together with contemporaneous research. And
sorry, when you said page 20, you meant with its own number.
Yes, I'm sorry. I checked with this and was told that the internal page, if it's running on from the electronic bundle, then it, I think, will be 1864.
No, it doesn't run on. It's a separate document.
It's
with its own.
Oh, yes, I can see that what I've done is I'm taking you to the internal pagination in the text, rather.
Page 7 of the electronic bundle, paragraph 1.71.
So I hope you have it now. It says Housing Act 1996 in the middle. And what one can see from that, page 1.71, paragraph 1.71, foreshadowed by a consultation paper referring to two main methods of acquiring a local authority or housing association: direct application or accepted as statutorily homeless. Then at 1.72, government research published contemporaneously. I can take you to the bottom of that section, the final paragraph. Against this background, the government's proposing measures to ensure fairer access to all parts of the rented housing sector include measures to prevent homelessness, to remove the distorting effect present provisions have on the allocation of housing, and to assure subsidised housing equally available to all those who genuinely need it. And at page 22, which I think will be 8, no, it will be 9, I think, the white paper, Our Future Homes, paragraph 175, if I can take you to the second paragraph in the indented passage there, local authorities will continue to have an immediate duty to secure accommodation for families and vulnerable individuals who had nowhere to go. So that was the policy background to the 1996 Act. And one can then see what the principal changes were if one goes over to page 23 of the internal pagination. We don't need to concern ourselves with 1.79. Don't need to deal with the first bit, which is about immigration control, but B, where the authorities satisfied there was other suitable accommodation available in the area, the duty was one for advice and assistance. Then C, in cases where that was not available, the duty was limited to 2 years. And then the authority was prohibited from providing its own accommodation in discharge of Housing Act functions for more than 2 years out of 3. That you may have seen or that part of the regime was the one that remained in force when Mr. Justice Collins decided the Begum case. And then, as part of that settlement, Part 6 was enacted, which required local authorities to comply with Part 6, only to make allocations to people on the housing register, and to adopt an allocation scheme. At the same time, the reasonable preference categories were changed. Homeless people didn't feature on them per se, but one can see from the list at 1.81 that many people who would fall within that class were perhaps brought in by some of the other groups, for example, families with dependent children, people with a particular need for settled accommodation, and so on. So the effect in 1996 was that Part 6 was to be the sole route to social housing. Homeless applicants had to qualify under that part like anybody else, and that's still the case. However, they were entitled to the benefit of a temporary duty, which is the term still used today, even though, and then a further important change that was made was that if the authority did accommodate in its own stock in discharge of its Part 7 duties, then the tenancy wasn't secure. So in other words, the qualified exclusion was replaced by a more far-reaching one, and that exclusion has been kept in force to the present day. It's Schedule 1, Paragraph 4 of the Housing Act 1985, which I think you saw yesterday, page 680 of the bundle. And what it means is that we know that temporary accommodation, despite its name, can last for many years, and no matter how long an occupier has been in such temporary accommodation, they can still be evicted for no reason, or any reason, with no protection other than the tenancy has to be duly terminated and a court order sought. So that was the 1996 position. Some homeless were reintroduced into the reasonable preference categories in 1997. I don't need to go to the detail of it, but it's at 1.83 of the Arden extract, page 26. And then the next significant change is the 2002 Homelessness Act, which was preceded by a green paper, A Decent Home for All, and one sees that at page 26 of the internal pagination, paragraph 1.85. And if I can just take you to the recommendation that we rely on for the purposes of this part of the discussion, at 1.87a, homelessness policy was intended to ensure that unintentionally homeless people in priority need were provided with temporary accommodation until they obtained settled accommodation in either the public or private sector. So it changed the 2-year, the idea behind the 2-year duty to one that was more open-ended. And one then sees what the changes were that were made. That's page 29, paragraph 1.94. The 2-year limit was repealed, and the Act took more or less the current shape that you saw yesterday. There have been changes since then. But it wasn't intended, one can see at 1.95, to last indefinitely. The circumstances which bring an authority's duty to an end were widened to include more reliance on assured tenancies, and those are the changes which are now in 1936CC. I don't ask you to go to it. And at the same time, changes were made to the Part 6 regime, and one sees the substance of those in 1.102. In that the requirement to keep a housing register was abolished, but changes were made to the regime to emphasise choice-based lettings. And finally, on this review, further changes were made by the Localism Act 2011, and the provisions that we have in the bundle reflect those changes. So the bundle at 681 to 781 is the Act as it stood after the Localism Act, but before the 2017 Act changes. And the 2011 Act was preceded by a consultation paper, and we can see the main recommendations of that at page 35 of this extract. The consultation paper was local decisions a fairer future for social housing, and at 1.115 summarised, under the current legislation, although local authorities have considerable flexibility how to meet the immediate housing needs of people owed the main homelessness duty, they're restricted in the way that they can bring the duty to an end. 6.8 made the point that those owed the main homelessness duty can insist on being provided with temporary accommodation until offered social housing, and they intended to give local authorities discretion to decide whether a person owed the homelessness duty needs social housing or whether their needs can be met in the private sector. And then on allocations, it recommended authorities being able to put in place arrangements that suit the particular needs of their local area. That's 4.9. And so the principal changes that were made for present purposes are that there was a new provision brought into section 193, which is in 1937 capital A, and that allows a local authority to compulsorily discharge the duty by an offer in the private rented sector that may be an assured short-hold tenancy. So in other words, one can discharge the duty in the private sector by a tenancy that doesn't confer security of tenure. There's then a provision about what happens if you reapply within 2 years, but that's the idea is to give effect to the recommendation that local authorities are given more choice about how to discharge the duty, and so it doesn't have and to make greater use of the private sector. And then the changes in relation to Part 6 were amended, among other things, to allow local housing authorities to adopt their own qualifying criteria for allocations. So in other words, the authority could define categories of people who couldn't apply for social housing at all, and those provisions are in 160ZA of the 1996 Act at 687. So, my Lords, I've taken you through that at some pace over changes that have taken place over a number of years. But the result is the overall framework has moved on significantly since 1977. The current regime is the product of repeated parliamentary deliberation, particularly since 1996. If one checks on Westlaw, the current version of Section 193 is version 10, so it's been repeatedly amended. The details of each change are perhaps less important than the fact that the 1996 and later changes represent part of the judgment arrived at by Parliament in the full knowledge of concerns about pressures on social housing and how fairly to balance the respective claims to it including claims from homeless applicants. That's the balance struck by Parliament. It's not one with which Croydon or the court can interfere. And thus, Section 1932 applicants have no entitlement to an allocation of council or social housing beyond that which the authority chooses to give them under the separate provisions of Part 6, first point. Second point is what they do have, and what the council must honour, and what this case is about, is an immediate and unqualified right to suitable accommodation that endures for so long as the duty hasn't been brought to an end. And it's significant, we say, that when enacting the 1996 Act and its successors, whatever was said about when the duty comes to an end, Parliament decided to retain that duty and to retain the requirement that it be for suitable accommodation. And thirdly, part of the balance is that although there is that right, it comes with no security of tenure, no matter how long the person's occupied. And each element of that balance is part of the balance struck by Parliament, and it's not open to the authority to say that they'll only decide to give effect to part of it. The limits of what the Council can do to order priorities between the various groups are found within Part 6. They're extensive, and they include the ability to determine that people don't qualify at all, but they don't allow the authority to reduce or qualify the Section 193 duty. But that's what Croydon's argument ends up doing. It ends up denying the immediate or unqualified nature of the duty because suitable accommodation is postponed, and it seeks to have it both ways. It ends up having people accommodated in unsuitable accommodation, but still not having security of tenure. So that's what we say about the parliamentary balance, and when one appreciates that, it becomes even more obvious, we say, why Croydon's headline argument must fail, whether it's put as an argument about the scope of the duty or about how discretion should be exercised. It runs counter to the balance struck by Parliament. I won't repeat what I've just said. It requires amendment, in effect, contrary to the plain words of the section. It's a point we make in our case at paragraph 78 to 9. But none of the matters that are relied on by Croydon come anywhere near showing that any implication would be appropriate at all, let alone the kind of radical reinterpretation or rewriting that would be needed in order to give effect to what Croydon say. If the points they raise ever had any force, which they don't, then they're simply out of date. They rely on matters such as lack of resources in 1977, the reasonable preference categories in 1977, but matters have moved on since then. And likewise, it's not possible to get any assistance from the fact that the homelessness legislation serves a wider public benefit and welfare purpose. Those might be good arguments when you're asking whether or not it is an Article 6 protected right and whether it creates rights in private law. But the same is true of many statutory provisions. But and there's the provisions I showed you yesterday. It's clear that this creates an individually enforceable right. And once that's recognised, then the fact that the legislation as a whole might be characterised as serving a wider purpose doesn't get you anywhere. Characterised as an argument on discretion, whatever the limits of discretion and whatever the role that resources may have to play, it can't be right systematically to exercise it in a way that undermines the balance struck by Parliament or rewrites clear legislative provisions. So I ought to deal with two authorities that are referred to in particular. One is Alibkiet, where you were taken to by Mr. Rutledge. That doesn't support Croydon. It's about drawing up a policy about offering accommodation in borough and suitability in terms of accommodation close to borough. And that's the balancing exercise that has to be made between various claimants. It's not concerned with a balancing exercise that results in any person not having their Section 193 duty complied with.
What page is that?
It's at the 826 was the passage you were taken to yesterday, paragraph 36 of the judgment of Lord Justice Lewison. What Lord Justice Lewison does say there, which we endorse, is he affirms that the role of the court as the guardian of legality. And I'll come on to that when I deal with the scope of discretion.
So what's your submission in relation to Appellant?
It doesn't assist Croydon because it doesn't address what Croydon need to show, which is that the Act at the discharge stage it enables Croydon to carry out some kind of balancing exercise between the needs of various competing claimants, the result of which is that somebody can be kept in breach of duty in unsuitable accommodation, which is the effect of Croydon's argument. Appellant was dealing with a completely different question, which is how, when you've got people already accommodated in suitable accommodation and you're contemplating either moving them on or discharging the duty, how do you decide where to put them when you've got various people who could equally have claims to being put in a particular property? But that's a very different question. The second case that Croydon places a great deal of stress on is Hendy. And yesterday, that I think was presented as a statement about the common law position on discretion. But what is relied on there is a minority obiter observation in an unreserved judgment about a different statute. And the suggestion that the court can decline to enforce clear statutory duties because of the moral claims of others, which appears to be the point that is extracted, is wholly novel and hasn't been adopted elsewhere. And it's notable that when Lord Bingham referred to that case in his lecture about whether public law remedies should be discretionary, he simply referred to the point whether the authority is doing all it honestly can to comply with its statutory duty. He didn't refer to that aspect of it. And he analysed it under the heading no useful purpose, and as an exemplification of the rule that the court won't compel a party to do the impossible and won't make futile or unnecessary orders. So he analysed it as an impossibility case, not as a balancing exercise case of the kind that Croydon would have it.
So was the decision wrong at the time it was made, or is it just wrong now?
Well, it's not. All that Hendy...
Maybe not the decision, but the observations. Not you're, I think, specifically referring to Lord Justice Scarman's
yes, I am.
observation, but of course, Lord Denning perhaps was even clearer, I suppose, than Lord Justice Scarman in what he said.
Well, he was, but that was in the context of a case where the applicant in that case was already accommodated in housing that was Lord Denning described as very suitable. The question wasn't about the provision of accommodation there and then. It was about whether, when you'd got suitable accommodation, nonetheless you should have permanent accommodation. Now, the Act itself didn't talk about permanent accommodation, didn't talk about routes into permanent accommodation. And all that Hendy actually decided was that the duty in question didn't impose a duty immediately to provide permanent accommodation. That was all the court had to decide because the claimant was already in suitable accommodation. And what Lord Denning held was that that accommodation was sufficient to comply with the duty for the time being. And we'd say that the key to what Lord Denning is saying is that, perhaps if we go to page 1550, it's perhaps helpful if one starts...
Not sure, did you say 1150?
No, 1550.
I forgive you.
It's perhaps helpful if one starts at letter D there. It's the last three lines, where you have Lord Denning saying, in these circumstances, and that's where she's already been given a council house at appropriate conditions. I think the local authority have done enough. They fulfil their duty if they let him have a council house on the terms normally offered to prospective tenants.
Forgive me. Which letter?
Letter D, third line
yes,
from the bottom.
Yes.
And so that's the decision, that the authority have done enough.
Yes.
And then when one gets to the bit between B and C, doing their best as soon as practical to get him other accommodation, that's the permanent provision, when the authority's already fulfilled its duty or fulfilling its duty. It's the kind of decision that in some of the earlier housing cases would have been described as stage discharge. And so what you have is an authority fulfilling its duty, but in a succession of properties. And all the case is deciding is that you don't immediately move to permanent accommodation. That was in the context of...
That passage refer to a duty. I cannot accept that submission. I think the local authority fulfil their duty.
Yes, well, we
What
can...
duty is he referring to?
The duty, if one goes to see what the statute said, it's 1549, letter D.
Sorry, it's page...
1549, letter D. D. Where a person is displaced from residential accommodation on any land in consequence of the making of a housing order, and suitable residential accommodation on reasonable terms not otherwise available, it shall be the duty of the relevant authority to secure he will be provided with such other accommodation. So the question is, are they providing you with suitable alternative residential accommodation on reasonable terms? To which the answer is, as long as you've got suitable accommodation now from which is occupied on suitable terms, that's enough. The town clerk, as a matter of fact, we know, was going to provide further accommodation, and all the authority had to do was get on with providing that further accommodation. But that was those two things together are sufficient to fulfil the duty. In the end, there's little one can get from Hendy that's of use to this case, because although there's some similarities between the statute and Section 193, it's a provision which is a separate statute. It deals with a different kind of accommodation duty.
So are you saying that Lord Denning's comments at C are entirely unobjectionable in the light of that particular legislation? Or are you saying that they are wrong even in that context?
No, we don't take issue with them as an interpretation of that legislation.
In the context of that particular legislation?
In the context of that, and in the context of that particular factual setup, the scenario, because the case would, we suggest, be completely different if at the time that Ms. Morgan, the time that the application had been made, that the claimant didn't have any suitable accommodation, because then the authority wouldn't have provided...
But you say that they had already fulfilled their duty.
Well, that's what Lord Denning says.
Well, I'm not... I think he says a bit more than that.
Well, they'd fulfilled their duty, yes.
He's talking about the fulfilment of the duty.
No, indeed.
And he's qualifying that by reference, isn't he?
Yes, but
taking into account everybody else's interests. In the housing list, isn't that what he's saying?
He is in that context, but in
I mean, you're saying... I think you're saying, well, that those remarks have to be read in the context of a case where the local authority has already performed its duty, as I understood you to say.
Yes, well, it's
he's addressing the performance of the duty.
He's addressing what they need to do after they've already secured suitable accommodation.
Well, he's talking about their duty, though, still.
No, well, that's right, but it's the...
He's saying, isn't he, that their duty can be performed by putting the person in temporary suitable accommodation and over the longer term finding permanent suitable accommodation, which has been done here.
Exactly.
Is what they're doing here.
Doing in Hendy, yes.
Hendy, yes.
No, exactly. And it's, as I say, it's an idea.
So they perform their duty by getting him other accommodation, and then beyond that, which is beyond the duty, there's nothing else.
Well, it's because the case seems to have been argued and presented on the basis that there was the end point had to be permanent accommodation. and in the light of a were, it's questionable whether that would actually be the right interpretation of the Act, but I don't need to go into that.
Right.
But on that basis, the duty is one that is performed over time. And as long as you've provided suitable accommodation at one point, you don't immediately have to provide suitable accommodation at a later point, but you have to take the best steps to do that. But that doesn't require you to give automatic priority, because you can then have regard to other considerations.
Yeah.
But that's a decision on the. That's all it decided.
Yeah.
And it's a decision about the content of that duty,
Right.
which doesn't help you decide what the Section 193 duty is, because we have an unappealed, unchallenged decision that that's immediate, unqualified, and non-deferrable.
Also, I think you're saying this doesn't help us with the common law principles in relation to when mandatory relief.
No, indeed, and with respect to,
because on your analysis, just to make sure that I've understood it, you're saying actually this was a case where there was determined to be no breach of the duty. So
yes.
That's why mandamus wouldn't lie, because there's been no failure to fulfil a duty. Contrast our case where there is a failure.
no, indeed, and Lord Justice Scarman made some observation about what he would have done had he found otherwise. But as I say, they were in an extempore judgment, and if he intended to go as far as to say that mandamus can be refused because of the moral rights of others or the unspecified moral rights of others, then he went too far. And that hasn't been picked up subsequently.
Yes.
And it's notable that Hendy, despite the somewhat foundational status that it gets in Croydon's case, wasn't referred to at all at first instance, doesn't seem to have surfaced at all in this area until the Court of Appeal decision, when it was relied on by Birmingham initially. I think it was also relied on by Mr. Rutledge in his skeleton argument. But if I can draw this together about what we say this means for the purposes of our argument about the end point of our criticism of the headline point is that it's always going to be wrong as a matter of principle for a court to be invited to refuse relief because it's a matter for the authority how they order their priorities for accommodation or how they balance their resources and the needs of others. The explanation before the judge presented by Croydon was put on the basis that was permissible, and it was bound to be insufficient.
And it was bound?
To be insufficient.
What was bound to be insufficient?
The evidence that Croydon produced to the judge, because it was presented on a false premise that the headline submission was accurate. But the remaining difficulty, and the one that really has to be confronted in this appeal, is what does one do, assuming the headline submission's wrong, what then is the role for resources? And the difficulty that we say any argument about admitting resources confronts, or has to confront, is that as soon as you bring in resources, you end up indirectly opening the door to Croydon's headline submission or a version of it, and that's the problem we say that has to be tackled, and we say the practical and principled solution is not to consider resources at all. Unless impossibility can be shown, we accept that if the authority can show that they can't comply with an order, then there shouldn't be one, because the court doesn't act in vain. But the court ought not to refuse relief for anything less than that. So what I...
Mr. Westgate,
yes.
in your written case, you do accept that there are cases in which it can properly be postponed, in which the exercise of the discretion to make a mandatory order...
Yes, we do.
...could properly be postponed. So how do you reconcile that?
Well, the two reasons. One is that... it's the point I made yesterday, that the court, when it grants time, may do so for reasons that don't necessarily or directly engage with resources, because what the court may be doing when it grants time is acting in a way that it will secure the fulfilment of the duty and the cooperation of the parties with least difficulty, if I can put it that way. The court normally will stay its hand if it considers that the duty can be fulfilled without having to make a mandatory order. The court knows that if it makes a mandatory order, then that might be challenged, there might be an appeal, there might be needs for enforcement processes. The court knows when it's faced with an application that it can't immediately produce the result, and so there may have to be some delay. So all of those factors can come into play in the court allowing a reasonable period. But even if one says, well, yes, but at the end it's all about resources, isn't it? Because part of the reason why it may be difficult immediately to produce a result is a resource-based one, then it's still not a counterexample, because one of the points we're going to make is that all discretions in one sense are objectionable, in the sense that they tend to undermine the statutory provision. But there is a material difference between ones that deny the right altogether and ones that have the effect of achieving the objective within a reasonable time, albeit a reasonable time imposed by the court. To misquote Strasbourg, it doesn't impair the very essence of the right.
Isn't the use of the word secure itself indicating that things might not be capable of being done immediately?
Well, not according to the unappealed finding that the duty is immediate, unqualified, and non-deferrable. Because it's the point that it's addressed in some detail in the El Kundi aspect of the judgment, that the emphasis on shall secure that it is available.
Yes. The duty may be immediate, but for example, if the duty was to be performed by securing that the person concerned obtains accommodation from somebody else, that necessarily would take some time. Or if it's to be provided by the local authority themselves, but accommodation needs to be adapted or perhaps purchased, that necessarily will take some time, even though the duty is immediate.
No, it would do, but and this is where the time-sensitive nature of suitability comes in. That it's clear from Ali, and again was accepted in the Court of Appeal in this case, that accommodation or what is suitable may depend on how long you're going to occupy it for. And so, of course, everyone knows that if you need adaptations done, then it may take some time for the builders to come in and do them. But the question then is, well, in the meantime, what is suitable for you? So the duty isn't to say, well, you can be put in unsuitable accommodation. The Parliament's answer to that, as explained in Ali, is to say that pending that long-term solution, there may be you have to be accommodated in accommodation which is suitable, but which where suitability may depend on how long you're going to live there. And the reason why we're here is that Croydon decided in June 2015 that this accommodation wasn't suitable, and so it wasn't accommodation that you could say, well, you can stay there until we find something else. They said that even allowing for all of the factors that we're allowed to take into account, this is accommodation that you can't be expected to stay in any longer. And Croydon have very fairly, in Mr. Beasley's evidence, said it wouldn't be fair to try and go back on that. So that's the answer, my lord, to my lord's point. It doesn't qualify the immediacy of the duty, the ability to achieve flexibility where a solution of that kind is needed, is achieved by ensuring that where you are for the time being is suitable. But the difficulty here is that decision was made in favour of Ms. Imam and against Croydon in June 2015, and she still stays in accommodation that Croydon said was unsuitable 8 years ago.
Can I just go back to
yes,
the
of course.
distinction you drew between, in effect, undermining totally the obligation or undermining it a bit? And you said that the analogy is with a Strasbourg test of not destroying the very essence of the right. I mean, how do you say that that distinction should be formulated?
Well, ultimately it has to be a matter that has to be decided on the facts of each case. Now, as the Court of Appeal decided in this case, there are a range of things that can be brought into account. They are things like how long someone's already been there, the overall circumstance, how far the accommodation falls short of suitability, the impact on the claimant, and factors like that. And ultimately, it does have to be a judgment formed by the judge. But of course, it has to be formed against the background that this is a mandatory duty that has to be fulfilled.
So is there any part of the Court of Appeal's judgment where some factors are treated as relevant but others are said not to be relevant that you dispute and say is wrong?
No. The point about this appeal is to test the proposition whether resources are relevant. We're not taking issue with
defending the judgment, not cross-appealing.
That's right. Although we do have some points where we say that we'd seek to uphold on other grounds. But yes.
Right. Okay. Thank you.
But you do go further than Lord Justice Lewis by insisting on impossibility.
Well, we say not when one reads what Lord Justice Lewis says, but can I come to that when I come to the Court of Appeal judgment? So this brings me on to what we would say is that the principled approach to resources. So would you bear with me one moment? Yes, so far as the principled approach to resources is concerned, we've got four elements to that. Firstly, the discretion to refuse relief is narrow.
Sorry.
4 points. Firstly...
This is, sorry.
Yes.
What's the headline point?
Sorry, the headline point is these are the points about our principled approach to resources. And the proposition that we're reaching for is that the practical and principled solution to the resources problem is not to consider them short of impossibility. And there are four elements to the argument that we seek to mount on that. Firstly, the discretion to refuse relief is a narrow one. Secondly, there's an established and orthodox approach of the court.
I'm sorry.
I'm sorry, Mr.
The discretion is a narrow one.
Narrow one, yes.
Yep.
Secondly, the approach of the court should be to focus on fulfilment of the duty and leave the manner of compliance to the defendant without bringing resources into account. Thirdly, that to consider resources undermines the duty. And fourthly...
I'm sorry.
It's a bit too quick for me, I'm
just
afraid.
going too fast.
I'm sorry, my Lord. I will probably get through this quicker if I don't try and speed up.
I think that's probably right.
Yes.
So the third one is... The third
is to consider that to consider resources undermines the duty. And fourthly, to consider resources produces intractable problems when adjudicating on them. On the first point, the narrow nature of the discretion, we set out a number of points in our written case at paragraphs 30 to 34, and where we draw attention to the fact that refusal to grant relief undermines the rule of law, and the power is strictly limited for that reason. I'm not going to repeat those. One point I do want to make on discretion, though, is what the role of the court is when it exercises its discretion. The discretionary nature of prerogative and private law remedies arises from the common law, although it has the imprimatur of statute, as the authors of Wade point out. The reference is page 1854. And we say that it's clear that when the court exercises its discretion, it's exercising its own primary judgment. That's expressly so, we say, in the case of an injunction where the section 31(2) of the Senior Courts Act says that the court may grant an injunction. But the important point is that for all of these remedies, the court isn't reviewing the judgment of the local authority. And we respectfully suggest that none of the cases suggest that that's what the court should be doing. And that's unsurprising, because it would be wrong in principle to do so, because the basis on which the remedial discretion arises is that the defendant is in breach, and it can't then be for the defendant themselves to decide on the factors relevant to relief. That has to be a matter for the court. So that's the first point. The second point arises from, we say, settled practice of the court. We say that the court's primary function is to determine the law regulating the relationship between the parties and to ensure it's complied with. It's not the court's concern how that's done, and it follows from that that it's not concerned with resources available to the parties to enable them to do so. And we say that supports the academic commentary we rely on in our written case, citing De Smith about the irrelevance of resources at the remedial stage. So far as authorities are concerned on that, I want to show you one authority and simply give you the references for the others. The authority I want to take you to is Attorney General and Colney Hatch.
I'm sorry, Attorney General
and Colney Hatch, which starts at page 853 of the bundle. It was a case about a statutory undertaker who were concerned with running the Colney Hatch Lunatic Asylum, and they discharged sewage into a river. It's page 853.
At the bottom of the page.
Yes, it is, yes.
Yeah.
And the passage, one can see from the headnote, where the plaintiff's proved his right to an injunction against a nuisance or other injury, no part of the duty of the court to inquire in what way the defendant can best remove it. Plaintiff entitled to an injunction at once, unless it's physically impossible, and it's the duty of the defendant to find a way out of the difficulty, whatever inconvenience and expense it may put them to. And it's an 1868 authority, but we say that the law has been, that's an accurate statement of the law from then to now. And if I can take you to the Lord Hatherley's judgment at page 860. It's the second paragraph in his judgment. Now I believe the court will always find it simplest course, as far as the administration of justice is concerned, to ascertain the exact state of the law which regulates the relations of the parties, and having done so, to proceed to act on it without any reference to the difficulties of the case on the part of those against whom it's obliged to decide. And then a little further down, on the next page, 861, about 5 lines down, no doubt there are cases where the court will take care not to pronounce an idle and ineffectual order. For instance, the court will not issue a mandatory injunction where it's impossible that the mandatory injunction can by any means be complied with. He gives an example of restoring timber that's been cut down. And then he goes on to say...
I'm just trying to find that passage.
So it's about 5 lines down the middle of the line, no doubt there are cases.
Yes.
And then about halfway down that paragraph, so about 11, 12 lines further down, where, having given those examples, His Lordship says, but that has no application, as it seems to me, to a case like the present, where there's no impossibility in the persons who are committing a wrong ceasing to commit that wrong, though it may subject them, and I agree would subject them in that case, to very considerable inconvenience. True it is that he does then go on to say that that might be a reason for recording time. And then if I can...
So this looks like a case of adjustment of private rights, is that right? It seems to be injunctive relief in respect to a nuisance.
Yes, it was, but it arose in the context of nuisance being caused in the course of discharging statutory responsibilities.
And can I just check, was Colney Hatch cited to the Court of Appeal?
No, it wasn't. And then at page 862, at the bottom of the first paragraph on that page, this court has nothing to do with the propriety or impropriety of creating new rights on the part of the legislature. The court has merely to decide what the...
I'm so sorry, I haven't caught up with you. 862, how far down the page?
862, it's about 8 lines up from the bottom of the first paragraph.
Oh yes.
This court has merely to decide what's the law as it exists, to see the duly administered, not to do anything to be, or order anything to be done which is simply impossible, is in the illustrations I've given, but to take care, subject to that modification, that persons shall be restrained from exercising of the high hand powers which they have no right in law to exercise. And then at 864, having considered cases where damages might be the proper remedy, at the bottom of that paragraph, the court is bound to grant the injunction. It's no part of the duty either of those who make the complaint or of the court to find out how that order can best be obeyed. And finally, in this case, in the following page, page 865, again at the bottom of the first paragraph on that page, about 5 lines up, to my mind it's made out clearly that there's no physical impossibility in restoring things to the state in which they were before the erection of the asylum. It's only a question of expense, and this court is not in the habit of listening to any argument on the ground of expense when it restrains the doing of a wrong. My Lords, we say that statements to similar effect are found in a number of other cases, including those that deal with the specific statutory context. They're set out in our case, and given the time, I will simply give you the references. The first one is the Poplar Poplar case.
Sorry, just before we move on to that, is there a discussion of how this case interacts with Lord Cairns' Act?
There isn't. One of the passages I just showed you was about whether damages would be an adequate remedy. But we...
I was just looking at the passage you showed us on page 865.
Yes.
If it's only a question of expense, court is not in the habit of listening to argument on the ground of expense when it restrains the doing of a wrong. But I thought that where the court is considering whether to grant an injunction or damages in lieu, it will consider matters of expense, won't it?
It can do, but the question then, one still has to then consider the position of the claimant, and certainly in a case like this, I suppose in principle it would still be possible to award damages in lieu, but it's hard to see how that could ever adequately compensate someone for being kept out of suitable accommodation.
Sorry, you were going to give us the references in your case.
Yes. So the first one is the Poplar case.
Which paragraph of your case is it?
It's in our case, paragraph 47.
Thank you.
And the relevant passage is at page 1641 of the bundle. Then there's Modern Homes, which is our case at paragraph 49. And the reference bundle is 1708 for Mr. Justice Maguire at first instance, and 1720 for Chief Justice Maguire on the appeal. And then in Exon Glasgow, which is footnoted to There's our footnote 16 to page 137, and the passage is paragraph 46 of Lord Eric's judgment at 1681.
Sorry, the third case.
The X in Glasgow, or Modern Homes.
Sorry, you've dealt with the
First one is Popular, second one's Modern Homes.
The third one.
Third one is X in Glasgow, which is our footnote 16, page 137. I hope I haven't got that wrong.
Yes. It is that.
And the bundle reference is 1681.
Thank you.
And we say the authorities are equally clear that if sufficient resources haven't been made available for the decision maker by a third party here, Parliament, or the application of the law bears too harshly on them, then that's not a matter between the decision maker and the court, but has to be taken up with Parliament, which alone can balance the various interests and policy considerations required if a remedy is needed. And for that, we rely on our ways in the Court of Appeal, referred to in our case at paragraph 46, bundle reference 1223. The Poplar case, referred to in our case at paragraph 47, bundle reference 1641, and Modern Homes, again referred to in our case at 49, Mr. Justice Maguire at 1709 of the bundle. So that is the second of our 4 points in relation to the in-principle position about the relevance of resources. Our fourth point is that having regard to resources tends to undermine the nature of the duty.
Third point.
I'm sorry, our third point. I'm trying to jump ahead. In general, where a clear duty has been imposed, then allowing resources to be taken into account will tend to have the effect of downgrading that duty into a power, particularly if the approach is to allow the authority some degree of latitude as to the resources to be considered and their impact. And that is objectionable for all the reasons that are normally deployed in relation to arguments against wide discretionary relief. As we've already noted from the Barnett and G case, the point of imposing a duty is to set priorities and to mandate how resources are deployed. And one can't undermine that by the exercise of a discretion having the opposite effect. Now, the leading case applying this in practice remains Tandy, where the duty was to provide arrangements for suitable education, which was defined as efficient education suitable to age, ability and aptitude. And the local authority had reduced the hours of support from 5 to 3, and they argued the duty didn't arise because of lack of resources. And if I can ask you to turn to the judgment of Lord Brown Wilkinson at page 1606. And it's really the passage from B through to E. And if I can ask your lordships to read that.
Was the question there whether there was a duty at all?
This was a case that was about the content of the duty rather than discretion. And so one could see that in that case, the effect of raising the point at the duty stage meant that the resources would be a matter for decision by the authority. and that's why one sees the language about turning a duty into a power. Before I come on to the way that applies to discretionary relief, we note really three things about the passage I've just asked you to look at. The first is on the point about not downgrading. The reference to diverting resources is very resonant, we suggest, of the approach applied by the Deputy Judge in this case, paragraph 81.5, where he talked about requiring the authorities to spend money they don't have or to reallocate resources, which is the same language that Lord Brown-Wilkinson is using. Secondly, Lord Brown-Wilkinson makes clear the inutility of having to rely on Wednesbury, as appears to be suggested in this case, where the authorities say, well, you should have challenged things like the budget decision, you should have challenged the policy, but the reality is that there's no realistic challenge you can make on a Wednesbury basis to decisions like that. And thirdly, the point that if the courts sanction the use of resources in that way, then they impermissibly reorder the priorities set by Parliament.
I'm sorry.
They impermissibly reorder the priorities set by Parliament. Now, what we say is if at the relief stage the court defers to the evaluation of resources by the authority, then exactly the same problem arises, because the effect is to make the council, and not the court, the effective arbiter of whether the duty is performed or not, and it becomes a power. But we also suggest that the same problem arises if resources are considered on a direct judgment basis, as it were, by the court as a factor that may excuse non-compliance. That creates practical difficulties we're going to come to. But even if those can be overcome, the court is still replacing the duty with the discretion being exercised by the court. And that is contrary to the point that we are entitled to live under a system governed by law rather than discretion in the face of duties of this kind. Now, it may be said that that's legitimate because the court's got a discretion, but the court still has to respect the order of priorities set by Parliament. And if they substitute their own judgment about what should be done based on resources available, then they're not doing that.
Yeah, but I mean, surely Parliament legislates against the background of understanding how the common law works in relation
indeed,
to
and the
grant of relief, where there is a discretion for the court built into that.
Well, indeed, and certainly the point that I've just made does raise a question, well, what's special about resources? Because every time the court exercises discretion, the same point might be made that you are intruding on the duty, to which we have three answers, and the third one will come on to my Lord's point, which is that firstly we would say that all such discretions are objectionable in principle for exactly that reason. That's why they've got to be very strictly limited. Resources, we say, are different because they raise special problems, because it's particularly difficult to confine consideration of them in a way that doesn't undermine the duty. But in contrast, other discretionary factors can more readily be evaluated and weighed by the court, and the court can perhaps not be seen to be stepping outside its constitutional role of simply adjudicating on the case in front of it, in the way that they do if they end up reordering resource-sensitive priorities that have been set by Parliament. And that will explain, we say, why matters such as delay, conduct, impact on the claimant and so on are matters that the court can take into account and evaluate without trespassing too far on impermissible areas of judgment and only intruding to a fairly minimal extent on the duty. Now, we accept that in one sense, one says, well, that's an unprincipled approach, and so it is. But it does keep the interference with parliamentary duties to a minimum. And that, we suggest, is part of the reason why we say delay cases are different from denial cases. I've had two goes at that point, and I'm not going to...
Refusing an injunction on grounds such as delay intrudes on the duty at all.
No, indeed.
The reason my Lord has given that in enacting the duty, the legislation is silent as to the remedy.
No, absolutely, but when
Trespass there.
when it comes to resources, though.
Well, I understand that's a different consideration.
Yes, when it comes to resources, Parliament enacts legislation, of course, in the knowledge that the courts have a tightly constrained discretion to refuse relief even in the face of a breach. But the fact is there's no settled practice of refusing relief altogether on resource grounds. On the contrary, we suggest the authorities point in the opposite direction. And therefore one can't say that legislation is necessarily passed on the basis of some kind of shared understanding that the courts might excuse compliance because of resources, particularly where, as here, Parliament struck the balance in the form that we've been concerned to explain, and where the very shape of the legislation is such that it's bound to involve the use of resources to discharge the duty. And indeed, those resources will need to be deployed to meet needs of people who are disabled or have large families. And that is something that Parliament must have contemplated as being part and parcel of the Act. To say, well, we recognise all of that, and we've passed this duty, but nonetheless, when you find it inconvenient to meet those duties or to deploy those resources, we can take that into account in deciding to refuse relief, goes far beyond the kind of understanding or assumed knowledge that one can attribute to Parliament in passing legislation of this kind. My Lords, that brings me on to now my fourth point, which is the difficulties that face the court in assessing resources.
Yes.
And this is our fifth point in our written case at page 140. But what we say is that particularly in a local government context, where a claim is about that it may be complicated and time-consuming for a court to inquire into resources, particularly if the point's being put on the basis of broad claims on the authority. And moreover, the court itself may lack the expertise to carry out an investigation of that kind, and the claimant may not be equipped to help them. They may have difficulty accessing advice, they may be a litigant in person. And the discussion of the housing revenue account point that we got into a little bit yesterday perhaps illustrates the problem. Does it mean that the parties and the court have to become experts in housing finance before they can start grappling with these kind of questions? And it raises a practical problem. If the court investigates this sort of thing in depth, then it embarks on a time-consuming exercise that's difficult and costly for the court and the parties, and is something that the court isn't normally suited to doing. Of course, it can do and must do if it has to, but it's not an exercise that the court would readily embark on. The alternative is that if it simply takes what it's told or defers to what the authority is telling it, then it's no longer exercising its own discretion, but it's embarking on a review jurisdiction, which isn't its function at this stage. Now, if it comes to it, then the duty is to enforce the law, and not what the council wants the law to be, and the court will have to investigate. But the real solution, we say, faced with these two unenviable alternatives, isn't to inquire into resources at all. And it's not simply a pragmatic outcome, it's consistent with the straightforward approach exemplified in Colney Hatch and the other cases, that it's not the court's function to consider how the duty should be fulfilled. And the difficulty in investigating, we say, is a reason why Croydon's claim that the Court of Appeal approach disproportionately disadvantages the authority that's genuinely resource-stretched doesn't assist, because we don't doubt the difficulties that many authorities face, but how is the court to decide which is the stretched authority and which isn't? Which is the authority that has failed efficiently to deploy its resources and which hasn't? And those aren't imaginary concerns, because as we point out in paragraph 58 of our case, there may be failings in management or on financial matters, and an authority may claim to have no resources, but that may in turn require an investigation about why that is and what's led to that point. As you will have seen from our paragraph 58 in the reports noted to that, Croydon itself was subject to a report process for that very purpose. And so are we really saying...
In terms of impossibility, it is appropriate for the court to look at resources.
Well, yes,
If the local authority says our budget is such, we're committed to such an extent, we simply cannot take steps this financial year, for example, it might say.
Well, this financial year may...
It's just whistling in the wind to order us to do it.
If there really is a case of impossibility in that sense, and what it really will come down to is impossibility in some legal ability to spend or raise further funds.
Well, they may be, exactly.
Then it's something that the authority ought fairly easily to be able to demonstrate. Obviously, they'll be subject.
Quite complicated.
It may be complicated, but it may be. They ought to know where they are. And so, although the financial and legal framework detail may be complicated, it's not something that will require a vast investigation by the court, because it's something that ought to be able to be. It's a hard-edged limit that the authority ought to know it's reached and ought to be able to demonstrate. If they don't know, then they really are in trouble, because they've then got to a situation where they can't legally spend the money, but they don't know they can't legally spend the money. So
it wouldn't really matter, would it, how they had got to that position?
Well, it does, because
You say, oh, well, you've been a negligent council, therefore we'll make a mandatory order, whereas if you've not been negligent, you've been hit by some unexpected disaster, we won't make an order.
Well, there is authority to suggest that where the impossibility is the product of past default.
You're still ordering the impossible. How can
well, a mandatory order has what that case is McLeod, which is I'm not going to take you to it because time doesn't permit, but it's it's a 1682. But in that case, the court held that in that sort of circumstance, then you'd still grant the mandatory order, but you might then take into account difficulties in complying at the point of any further process to commit. And I appreciate that simply pushing the can down the road a bit. But the point behind it is that making a mandatory order is a way of the court saying, well, this absolutely does have to be prioritised. You simply can't come to court and say we're trying our best. And so it still serves a function. And so
I think I was possibly just quibbling a little bit with you, yes, saying that the court must never address the issue of resources. I think you accept there are circumstances where the court will have to.
No, indeed. But short of that, is it really to be said that the court should embark on this sort of vast investigation when there's a much shorter route available to them? And the limit on that shorter route is impossibility, as we accept. And the only case where relief was refused outright because of resources has been one of impossibility in that sense. It's the Bristol Railways case. Again, I'm not going to take you to it because of time, but the page reference is 1657. It's referred to in both cases. And that was a case...
Sorry, what's the reference in your case, just so we can keep...
It's... I'm sorry, Lord. It's... Yes, it's in paragraph 59 under our cross-heading impossibility. And that was a case where a railway undertaker had to construct a bridge over a turnpike road. Oh, no, the other way around. The turnpike road had to have a bridge going over the railway rather than level crossing. And its assets had been taken over by another company. Its share capital was spent. Its borrowing powers were exhausted. It was, in the words of the judgment, virtually defunct. And so there was no possibility that it could ever carry out the function. And in that basis, the order would be futile, and so no order was made. And we suggest that's something that doesn't interfere with the principle that we've been discussing, because the basis of an order isn't about evaluating resources, it's that there simply is no way this can happen. And we say it doesn't interfere, or at least not as much, with the court's function, because, for reasons I've just said, it's something that ought to be able to be fairly readily demonstrated, because an authority that knows that it's up against those limits should be able to show why and how. In practice, we accept that it's difficult to think of circumstances in which impossibility like that can be made out in a case involving local authority. They don't go bankrupt in the same way as companies. They don't become defunct in the same way. They have a wide range of powers, including to acquire, build, adapt, borrow, and so on. So, as a matter of practice, it may well be very difficult for a local authority to show impossibility in that sense. But we say there's nothing wrong with that, because what we're concerned with here is the fulfilment of a mandatory duty. And if the authority can do it, i.e. it's not impossible, then they should do it. And it's worth repeating here that Croydon has never said that it can't fulfil its duty. And that's why it's had to present the argument that it does in the way that it does, not on the basis that it's compelled to deny Ms. Imam's right, but on the basis that it can choose to do so by prioritising something else. Can I say something very briefly, because I do have to get on to the Court of Appeal decision, about the position of third parties, because it's something that is around in the submissions but hasn't been expressly addressed. Our discussion of the relevance of resources focuses on the fulfilment of the duty owed to the individual. Croydon say you can't approach matters on a bilateral basis in that sort of way, rather than considering and balancing the needs of others. Now, Croydon pursue that argument at what can perhaps be described as a high level. They say that they can balance all these competing demands and the court can't second-guess their judgment. And put in that way, we suggest it has to fail for the same reasons as the headline point. And the court, accordingly, can't be invited to deny relief because of unspecified competing demands of what's been described as the multitude. That's a phrase that is borrowed from a different context in Ahmed. But that was, in substance, the position that was accepted by the Deputy Judge, who took account of the unspecified impact on others of granting relief. That's paragraph 81.6, page 310. And he expressly referred to the court's inability to weigh the claims of the multitude, 81.8, 311. Now, and so for that reason, the way in which competing claims was dealt with in this case was erroneous. But we do accept there's a separate issue here, which is whether the claims of third parties, if properly evidenced, could be a reason to refuse relief. And it's a point on which the Court of Appeal didn't express a direct view, but raised the possibility that that might be the case. The reference of that are Lord Justice Lewis at paragraphs 142 and 145, where he left open the question whether the unfairness to other applicants could be a reason to refuse relief. But the difficulty for this court is that the court doesn't have any facts that enable any meaningful discussion of that proposition to take place. Our in-principle position is that it can't affect the approach of the court to the individual case before it, because the fulfilment of the individual duty doesn't depend on the position of other people or the impact of other people of having the duty fulfilled. And if relief is denied because of the impact on others, then the court's failing its duty to enforce what Parliament has required to be done. And we say if the claims of third parties aren't based on similarly unqualified rights, i.e. that, for example, they're Part 7 claimants, then the principled answer here is straightforward. Croydon has to fulfil the duty and can't rely on the lesser interest of others to decline to do so. At least it's got to explain why it's not doing so. And there may be explanations, but we don't know what they could be. The same point, we say, arises even if the competing claims are those owed the Section 193 duty or a similar duty. And that, we say, is the other side of the coin to the issue identified by Baroness Hale in Ahmed, reference at 1194, that just as the court can't weigh the claims of the multitude, so the court's function is, and its expertise is, to focus on the individual claim and the facts of the case.
Oh, I'm so sorry, I missed the Ahmed reference.
Yes, it's 1194. And as with the resources point, we say that in principle argument is supported by more pragmatic considerations, that it's going to be difficult very often to evaluate what the competing interests should be. And contrary to Croydon's argument, this isn't unfair. It's not a case of to the litigator the spoils. Again, Parliament has litigated in the knowledge that it's created an individually enforceable right, and it knows that that's how individual rights are enforced. If Parliament wanted a different enforcement mechanism, it could have done that. Now, we accept that this might be thought in some ways to be quite an austere approach that denies altogether that there might be interest of third parties that could be taken into account. And as we say, it doesn't arise on the facts of this case, because the general claim is the basis on which it was put by Croydon.
Well, it may do, because what the Court of Appeal have done is remit the case for further consideration. So these factors may be relied upon.
Well, they may well be, but our primary position is as I say, the somewhat austere one that we've just put. What we would urge the court to caution is that we would say that the principal answer is the right one, but that if you're going to say anything else about it, then to be very clear that it's not. It very much will depend on the individual facts.
Do you deal with this in your written case? We do, but fairly briefly. It's our written case, paragraphs 82, 93, and 11728.
Just repeat that, please.
Yes, 82, 93, 11728.
Thank you.
The Court of, Lord Justice Lewis took a different view about this, didn't he?
Well, as
145, he says it may well be that.
No, indeed. He certainly left open the possibility that might be the case, but he didn't. What he didn't do was examine what those other reasons might be and how one would evaluate them.
He postulated it may well be that if there are a number of people waiting for suitable Part 7 accommodation, it may be unfair to make a mandate.
No, indeed.
It goes on to say, but there's no evidence.
Yes, but it's an issue that perhaps is better resolved when we know some facts about what is exactly being said, rather than being compelled, because this case is being brought as on a somewhat abstract basis.
But I didn't understand you to be saying that what Lord Justice Lewis said in paragraph 145 was wrong in principle. He's clearly. The case is being remitted.
Yes.
So it's going to be examined further in the light of more evidence. That's the whole point of remittal. And Lord Justice Lewis has indicated that it may be that if evidence is brought forward showing unfairness as between Part 7 applicants, that might be something which shows that a mandatory order ought not to be made. Well,
our written case does take the point that I've just made and does raise as an additional reason for upholding the decision of the court that it's wrong to take account of the position of third parties. So
your sort of secondary submission, if that isn't accepted, as I understand, is you should only take into account concrete cases.
Well,
not the abstract possibility of other competing claims. If you can show tangibly that there is actually only a choice between two people, let's say, and the other one has a strong claim, then that might be something a court could take into account.
Well, but my principal fallback position is you should wait for a concrete case to come along and then decide those questions when that happens, because it's dangerous to speculate about what may or may not be a good reason when you don't have any facts before you. But in direct answer to the Lord's point, that's not our fallback point, but I certainly can't say that we exclude altogether that possibility. Can I now, I'm afraid at rather long last, come to the decision of the Court of Appeal?
Would this be a convenient moment to take a...
Yes, it would. Yes.
We'll take 5 minutes.
Yes.
Westgate.
Yes, the Court of Appeal decision. Can I start by setting out, in summary, what we say the Court decided? We recognise there was another way of reading what the Court decided, but and I'll come on to that. But the Respondent's case is that the Court of Appeal decided that resources were not relevant at the discretionary relief stage. It didn't reintroduce that by the back door through references to reasonable steps or other accommodation. And to do so would be to run counter to general principle that we've discussed. On that basis, the relevance of reasonable steps is to address whether compliance is possible, and we've explained why we say the threshold is possibility. And we say that the Court of Appeal decision is addressed to that. In other words, the discussion of reasonable steps is about the issues that arise when the authority claims it's not possible to comply. That's paragraph 132 of the Court of Appeal's judgment. Now, we recognise in making that submission that another view might be taken of what the Court of Appeal decided, and it's one which was canvassed in discussion yesterday, that the Court decided that whereas a general appeal to resources wouldn't suffice, that might be relevant if one is making a more specific claim about particular things that could or couldn't be done. And in those circumstances, if that's what the Court of Appeal meant, then reasonable steps, and the reference to reasonable steps will be reasonable steps that might in themselves include resources. But it's less easy to see how steps of that kind relate to some kind of possibility test, because one is then independently evaluating what the steps are and whether they're reasonable. But, my Lords, the essential point for the disposal of this appeal is that on either view, the Court was correct to hold that the Deputy Judge erred in the way in which he had regard to the limited resources available to the authority. That's paragraph 141 of the Court of Appeal's judgment, page 265, referring to paragraph 82 of the Deputy Judge's judgment. He had regard to resources in a general sense, which we say was clearly an error. And that's something that we've dealt with in some detail in our written case, and we don't repeat those points. There is one point, perhaps, that makes that point, makes the point in which the matter was put before the Deputy Judge, and that's the £69 million deficit point. Because that can only be about general resources and can't relate to purchase, because that's not how you fund purchases of properties to be used as housing accommodation. That's done by borrowing against the revenues of the HRA, the Housing Revenue Account, which is a ring-fenced account. And so if the authority wanted to make a point about whether it could borrow to fund housing, then what it should have done was address the position of the Housing Revenue Account and not its general fund. There are other grant options and matters of that kind, as Mr. Downey's statement states. But if Mr. Beasley meant to say, we can't buy, then that's what he should have done. And there's one further point we make in relation to finance arrangements like this, which is that the point was raised before the short break about, well, what if an authority says we simply can't afford it, we can't borrow, we can't do any more. But the reality is that when one is talking even about the cost of purchase, it's vanishingly unlikely that an authority would be in a situation where it couldn't, absolutely couldn't, fund something of that kind.
But it might not have been able to in September 2008, when the banking system froze.
One can see that there may be circumstances where we're not ruling out impossibility.
Exactly.
But they borrow from central government, don't they?
Yes, against Public Loan Works Board. They can borrow elsewhere, but from government is the best option. So the appeal ought to be dismissed purely on that basis. But that has an impact as to the correct reading, as it were, of what the Court of Appeal decided, because this court, as long as it is satisfied that the court was right to remit the matter, it isn't committed to any particular version of what the Court of Appeal said. It doesn't have to simply adopt one of those. And so for that reason, even if you disagree with us about what the Court of Appeal actually said, we say that our analysis is the principled one that this court ought to adopt. And the end point of the inquiry on our analysis is to say that reasonable steps are a way of arriving at a conclusion about what is possible and not possible. So can I come on then to what the Court of Appeal decided? On our first point, that resources or budgetary constraints aren't relevant to the exercise of discretion, that was said on several occasions by the Court of Appeal in terms that were unqualified. And given the time, I'll simply give the references on that. It's paragraph 131, the last sentence, where having identified a range of factors, Lord Justice Lewis said resources and financial constraints aren't relevant. It does include the words of itself, but we say that's an insufficient basis to say that resources are being included. Then there's the last sentence of paragraph 137, referring back to 131. That again is unqualified.
Well, just on 137, Lord Justice Lewis seems to be drawing a distinction between what could be described as resources in one sense, if one accepts that resources is a rather ambiguous term, which is limited number of satisfactory properties, as distinct from the wider budgetary.
Indeed, I will come on separately to deal with why we say separate property, availability of properties doesn't undermine what we say.
Right. So I just wanted to check.
Yes.
Are you quarrelling with the correctness of what the Court of Appeal says in 137?
As long as it's understood that the focus on what the authority's done all it reasonably can is to decide what is possible, then we don't quarrel with it. But if one says, well, you look at what's happened and ask in an independent way, is this reasonable? Then we would take issue with it. And then to follow up our references on resources, paragraph 141, the second sentence in the criticism of the Deputy Judge, and again, that's unqualified, and the irrelevance of resources is twice expressed in this paragraph, and it's notable in that paragraph that the reference to suitable properties being available is sandwiched between two references to resources being irrelevant, which suggests that the court can't have had in mind that they qualified those statements. Then there's the 148 first sentence, which identifies the Deputy Judge's error. That is similarly unqualified. And then there's the conclusion at 152. And what we say is that, consistently with our analysis, Lord Justice Lewis accepts that an order may be refused where it's not possible to comply, and that reasonable steps are a way of showing that. And for that we rely on 132, first sentence, where the entire discussion is introduced in the context of asking whether, or addressing a situation where the housing authority considers it not possible for it to secure that suitable accommodation is available. Then 133, the references to passages or terms used in previous authorities refer to possibility or factors outside control. And then 134, one has the evidential link between reasonable steps and what may be possible. And then at 142, the explanation of the judge's error at lines 4 and 5.
Sorry,
142. Yes. So the judge's error is that, and this is on the second point about the Part 6, Part 7 point, but it says, hadn't provided evidence, had taken all reasonable steps, and either it had not been possible or there were other reasons why it was inappropriate. So in other words, if it is possible, the only way you can avoid the order is to show some other reason why it's not appropriate to make it. So those are the references on which we rely. And we said it's not the case, as the appellant claims, that references to reasonable steps imply resources, because if they're judged, as we say, from the perspective of asking what's possible, then the important question isn't, and I've started echoing here, I'm not quite sure why, perhaps I'll step back a bit. Then the important question isn't whether the steps had some inherent quality of reasonableness or otherwise, but whether it's a step that can reasonably be expected to secure the availability of accommodation. And when you look at it in that way, it makes it easier to understand the references to limited properties being available. So, for example, consider a situation where a claimant needs a 4-bed property, but the only properties that the authority has are 3-bed properties. That would mean it would be pointless to try and rearrange the properties or to look in that existing stock. But of course it leaves open the further question, which is, well, what should you do to augment that stock? So one can simply say, one can ask, well, is it a reasonable step to look within your own stock? No, because it's simply not going to produce what is needed. Are there other reasonable steps you might take? Yes, they include purchase. And one can make the same points in relation to market inquiries and things of that kind. An example of something like this is Mr. Beasley's evidence about Home Finder UK, where he said that wheelchair properties in London are scarce, but that's something over which Croydon's got no control in relation to that organisation. And so it may not be reasonable to make inquiries with them and so on. Other examples might be if there's a legal prohibition on additional stock or expenditure, and could mean that steps like that, and unlawful steps, would never be reasonable in that sense. And none of the Court of Appeal references to reasonable steps or alternative properties say that resources are relevant to that question. And the references there are 132, 134, 137 and 141. And so, in summary on what we say that the decision of the Court of Appeal was, we find it difficult to see, and we've already made this point, when something actually will be impossible, in this sense, for a local authority. If all lawful options to secure accommodation have been exhausted, then that may be the case. Otherwise, it will be possible. But there's nothing unacceptable or irrational or unfair in requiring an authority to take all lawful options to secure that the accommodation is available. But the difficulty that arises here, again, as with the position of third parties, is that Croydon has brought the matter to this court without us having any detailed facts. And so, whereas I'm forced into the position of saying, well, I simply can't envisage a situation where it might not be possible, we don't know how Croydon would try and make that out if they can. So far, they haven't even claimed that it's not possible. So, if they'd chosen to advance a case, then it might have been possible to evaluate one, but there is no such case before the court. And so the effect of our approach to the Court of Appeal's decision may be that local authorities will not be able to show, or very rarely will be able to show, impossibility on that basis. And if that's the case, then perhaps they ought not to try. But that in itself is not an objection, because we are concerned here with a mandatory order that needs to be, or mandatory duty that needs to be complied with. And so to say, well, it's difficult for authorities to show that an order shouldn't be made, isn't an answer to that point. And so it may well be that where we've got to, perhaps by a more scenic route, is back to the Colney Hatch approach, that the court should simply ask what the duties are in the parties before it, and ensure that the law is obeyed. And so, in summary, the correct reading of the Court of Appeal, or at least the one that this Court should endorse, is the question is whether the action is possible in the individual case. The authority may be able to show that it's not possible if they've taken all reasonable steps, but in context, that means all lawful steps capable of fulfilling the duty. So there's 2 points. Third point, the Court of Appeal's right to decide that resources aren't relevant, and they're not relevant to the evaluation of what are reasonable steps. And we accept there may, fourthly, we accept there may be some cases
So
where...
the third point was?
The third point is that the Court of Appeal's right to decide that resources are not relevant. The Court of Appeal is correct to decide that resources are not relevant.
Yes.
Well, I thought that was your first point, but
It's and it's and so the Court of Appeal is correct also to dismiss the appeal because on any basis the judge erred. So can I make some?
You mean allow the appeal?
Yes.
Why was it appropriate to send it back for another hearing, 8 years down the line?
Both sides wanted to put in further evidence, and it's what Lord Justice Lewis left open was the question whether there might be some other reason why an order ought not to be made, and so it was sent back on that basis. We haven't cross-appealed on that, but I can see that.
How many chances do you get to put in evidence if you're the local authority?
No, indeed, but the authority could perhaps say, well, we didn't anticipate exactly the way the Court of Appeal is going to put it, and we want to put in evidence that addresses that. But there was no disagreement about the matter being remitted. But I can see the logic of my Lord's point that if we're right about resources, then that ought to have carried the day. But the issue before this court is, and certainly why we've ended up here, is given that Croydon aren't pursuing a claim that is actually impossible for them, it's really to test their headline point, which is wrong for the reasons that we've indicated. My Lords, I've got some short points that, well, there's a number of points, but they go to what the position should be if you're not with me on that approach, and if you favour the idea that general resources should be discounted but specific ones might not be. And that is an extremely hazardous approach in our submission, because it leads into the headline approach being adopted in substance, if not in form. And if one is to go down that kind of route, then one has to recognise that it is an invasion of the principle that the duty should be obeyed, and undermining to the rule of law in that sense. And therefore the court ought to devise ways in which, if resources are going to be taken into account in that sense, then it does so to the absolute minimum, rather than leaving open some wide discretion. And so, as a bare minimum, the burden's got to be on the authority, and the inquiry's got to be focused on the need to comply with the duty. And we would suggest a number of minimum elements. We've got 8 of them. I've got quite a lot I want to say about all of them. I'm just going to give you the headline points, given time. Firstly, the decision as to what's reasonable would have to be a matter for the court, not for the authority. Secondly...
We're going to have to take this a little more slowly,
yes,
because we're going to make an end of it.
Secondly, it will always be reasonable to expect the authority to exercise the full range of its powers to secure suitable accommodation. Thirdly, expenditure incurred in the exercise of those powers will always be reasonable, and in particular, it will be reasonable to meet the exceptional housing needs of disabled people or others with exceptional needs. And that is an important aspect of this, because the Act contemplates that such people have just the same right to housing as anybody else, and there are obvious equality implications that we've addressed in our case, but I won't, for reasons of time, expand on them. Fourthly, the authority must be able to explain in sufficient detail what it's done and what it hasn't done. It has to be able to explain what other legal options are available and why they haven't been adopted. Fifthly, the authority has to be able to explain that in relation to the claimant, rather than simply relying on general processes. Sixthly...
Sorry. Could you just elaborate that?
Yes.
Five. What exactly do you mean?
Well, the point is, in this case, what Mr. Beasley did was he says, well, we consider it for every property that becomes available. We look for properties in the private rented sector, but what they haven't done is explained how that search relates to this individual claimant. So it's not good enough to explain general processes. What you have to do is say, well, this is a duty we owe to this claimant. This is what we've done to find accommodation for this claimant. So my sixth point is that the explanation's got to cover what action's been taken to plan for need. And that's a point of particular importance here, because Mr. Beasley says there's a chronic lack of adapted property, but we know nothing whatever about what they've done over successive years to do anything about it. And it's a problem that seems to have gone back to 2004 or before, because one of the examples that's given is a case that's been going back to then.
How does that work? Because one might think that impossibility relates to the current situation, so far as one's looking to the discretion of the court.
Well, Lord, the point I'm addressing here is if strict impossibility isn't the approach, and the correct approach is to allow resources to be taken into account in some sense. And so, in that case, it is highly relevant, we suggest, for an authority not to be able to say, well, we are where we are, and to rely on unchallenged budgetary or policy decisions, when in practice it's impossible for a claimant to challenge them. Seventhly, and it's a related point, the authority must be expected to show what it's done to address any deficiency over the whole of the period.
Sorry, it must show what it's done.
Show what it's done to address any deficiency over the whole of the period it's been in breach. And eighthly, the emphasis has to be on all reasonable steps and not just reasonable steps. Now, my lords, authorities may say, well, that's all very onerous, but then that's not an answer, given that the effect would be to relieve them of the consequences of breaching a clear duty. Put simply, it shouldn't be easy for them to avoid that. And in any case, it shouldn't be that onerous, because these are all things that an authority ought to be doing anyway. And if they're serious about fulfilling the duty, then they ought to be able to evidence what they've done, both generally and in an individual case. The practical effect, we accept, is that there may need to be something extraordinary to permit an authority to avoid the duty, rather than the sort of things that would arise in the ordinary course of doing what you're meant to do. My lords, that leaves me with the specific criticisms of the Court of Appeal's decision are matters where we broadly deal with those in our written case. And I don't want to take up time just repeating what we say there. On the resources ground, our case is at page 152 of the bundle.
Paragraph.
It's paragraph 98 is where we start, and then on through to 100 to 103. So it's In fact, it's 152 to 155. The only point I'd expand on that is that apart from the textual points they raise, Croydon rely on the argument that because resources are taken into account earlier, they therefore can't be taken into account at the Section 193 discharge stage. And the Croydon seem to argue that that is an impermissible line of reasoning because there might be cases where that's not the case. But that really is to miss the point about what the court's saying. What the court does is describe the balance set in the statute, and if that is the balance set in the statute, the court can't be in error for following it. So far as the reasonable steps point is concerned, again, we deal with this in our case at 104 onwards, paragraphs 104 onwards, pages 155 to 156. The Croydon starts with a pleading point, and I'll come back to that very briefly. But as to the substance, again, we rely on our case, but in relation specifically to Croydon's point at paragraph 67.2, that it's not for the court to direct the authority how to allocate its own stock, it reveals a misunderstanding of what exercise the court is engaged in. Firstly, it's the court's own discretion whether to make an order. Secondly, court's own discretion, point one. Secondly, if it made an order, it wouldn't require any specific grant. It would simply order the duty to be performed, and the council could perform in any way it lawfully could. But it, thirdly...
Sorry, I have to...
Yes.
This for a moment. Yes.
Thirdly, the court needs to be able to understand what the council has done the council needs to understand what the council has done in order to decide what to do. And if, fourth point, if that, or requiring that explanation, is an impermissible intrusion, as the council suggests, then so is any interrogation of what the council has done. And that would be to empty the discretion of any effective content, because it would mean the court could never ask the appropriate questions of the authority. The second point we make on this ground is that the Court of Appeal didn't confine the lack of reasoning in the council's evidence to the Part 6, Part 7 point. That was an example of overly vague or overly general evidence that was put in. And that's the point that the court makes at paragraph 142, when they say that the authority had had 6 years to comply, and they had to do more than produce very general evidence. That conclusion hasn't been appealed, and there was another example given, which was about purchasing, and that's at paragraph 145 of the Court of Appeal's decision. Again, that decision hasn't been appealed, and it was justified for the reasons we give in our written case.
Sorry, what's the point of 145?
145 is that Mr. Beasley didn't properly explain why they couldn't purchase.
Yes, thank you.
And the overall complaint about generality is, we suggest, amply justified, because he not only fails in those respects, but he fails to explain concepts like accommodation becoming available, what active searches mean, why they didn't adapt the property, and what they had done to plan for additional wheelchair accessible stock. Now, well, can I, before I finish, raise or deal with the pleading point. There are two parts to this. The first is the narrow point taken by Mr. Rutledge that the Part 6, Part 7 point wasn't raised on the pleadings. We say it was, and I don't propose to take you to the detail of what was said and what's in the agreed note. In a case of this kind, there should be we suggest a liberal approach to pleadings and what they've said, particularly given that one's having in effect to retrofit pleadings to a judgment of the Court of Appeal that may not exactly match the way that the parties saw the dispute beforehand. But there is Mr. Rutledge has a particular point about replies that I'll try and deal with in relation to my next point. We've also got what can perhaps be described as a counter-pleading point on this, which is that this is the very first time this point was raised was in the appellant's written case. It wasn't part of the grounds of appeal, wasn't raised in the Court of Appeal, and we respectfully suggest it's far too late to raise it now, and this court shouldn't be concerned with matters of that kind when they're raised before this court at the first time. What may be a matter of greater concern is whether the premise for the pleading point is right. And this is really my second point, because for these purposes, we don't disagree with the all reasonable steps approach as a way of testing possibility. But there's a danger here of the tail wagging the dog, unless you take care about what has to be shown and where the burden lies. Because Croydon says that procedural rigour means that all relevant breaches have to be pleaded and identified. But that fails to recognise what's going on here. The breach of duty here is failure to comply with the Section 193 duty. The issue then is one about how the court should exercise its discretion. And so one asks, well, what should a claimant be pleading?
On the discretion point?
Yes, because the appellant relies on the practice direction to Part 54, which suggests that each ground of challenge should be properly particularised. And although that wasn't in force at the time, we're happy to accept that that's a statement of good practice. But the ground of challenge is that Croydon's failed in its duty.
Is that Croydon
has failed in its duty. And that's it. That is all that the claimant needs to demonstrate. Obviously, she might need to demonstrate other matters to get off the ground to show that it's been going on long enough for the court to be interested in granting relief. But in those circumstances, there's a serious question about what the claimant should plead in these cases and why the claimant should plead, why the explanation is deficient. It might not be fully explained in pre-action correspondence, and indeed, in this case, Croydon didn't respond to the pre-action letter, so there was nothing for the claim to engage with. Normally, the defendant's explanation will come, and it was here, in the evidence that's filed with the detailed grounds. By then, the claim's been issued, permission's been granted, and the rules don't provide for a reply. And even if they did, Mr. Rutledge's point is going to be that a reply can't introduce new grounds. So
your point is it's not a ground at all. In fact, it's just pointing out the inadequacy of the
exactly
that is relied on to show it's impossible.
Exactly, but it's more than simply a procedural point, because it raises a question about how these cases should be addressed. Because Crisis makes some points about the burden of proof and the difficulties that would arise if the burden of proof wasn't placed on the authority. But exactly those problems apply with pleadings as well, that claimants may lack the expertise or knowledge or ability to particularise exactly what it is gone wrong, and that's what the authority know about, not what they know about. And so this isn't about setting a trap for the defendant. There are, we suggest, many contexts where one party bears the burden, and they run the risk, if they don't put in enough evidence, of simply being told that what they've put in isn't enough. Applications for relief from forfeiture might be one example. And of course, if there's unfairness, then the court can deal with it. But this court, we suggest, shouldn't endorse an approach that says that in a case of this kind, it's incumbent on the claimant to identify and particularise all the things they say the authority should have done. It may be that in some cases some directions might be given to sharpen the focus of the issues, but the starting point here, if this is the approach to be taken, is that it's got to be for the authority to explain. The authority's got to satisfy the court because the authority knows what it's done, and the authority, to a large extent, is the person in whom the expertise is reposed, and their duty of candour will require them to give a frank explanation. That leads to our additional grounds, which I will deal with in 2 minutes, because they are largely repurposing points that we've already made in submissions. With one exception, we don't accept that those grounds weren't sufficient to be raised initially, but that's something which has to be seen in the light of the point I've just made. But so far as additional steps are concerned, there are 5 points made. One is about rental accommodation. We suggest it's not correct. That has been adequately addressed by Mr. Beasley. He doesn't deal with what steps have been done to source that accommodation.
Sorry, where are you in your written case now? Is this paragraph 110?
It's the additional reasons, paragraph 110 onwards. Well, I think given the time, I'm just going to rely on what we said there. So far as the one particular point we do raise, though.
Mr. Westgate, we interrupted you this morning for longer than we should have done, so you've got a few minutes.
I don't want to take up any more, but the fact is these are points that are set out here, and we don't really have much to add to what is being said. But one point we would emphasise is paragraph 116, where we say that it ought to have been held that Croydon had failed adequately to explain what steps it had taken consistent with the public sector equality duty proactively to plan. And the point is taken against us. Well, this is raising a PSED point that hasn't been revived in the Court of Appeal. But that's not really where this point is aimed at. What the point's aimed at is what's been done to plan. Of course, any plan that does happen would have to be compatible with PSED. But the starting point is, so what have you done? And the answer from Mr. Beasley is nothing. The only other point we'd emphasise is the adaptations to the current property point, because, again, that's not something which is addressed by Croydon. But at the time of the hearing, they accepted they were going to consider adaptations and said they were going to get a further report. They hadn't done that. The judge recorded they hadn't done that, but rather left that hanging. It's what we would suggest is an obvious step, and it certainly hadn't been taken. And the other points are about the judge's decision and whether he should defer to the authority. That really has been canvassed here. I don't think I need to deal with it as a separate ground. And then the point about third parties is the Croydon's response to that is that, again, that would be an impermissible intrusion with the judge taking it upon himself to decide what priority the claimant should have and how the authority should allocate its resources. But that, we suggest, is an exactly wrong characterisation of what the position is. And at the risk of repetition, this isn't an allocative decision for the authority. The balance struck by Parliament strikes an individual right, and so the judge isn't making any allocative exercise themselves. What they would be doing is seeing what the statute requires and enforcing it. So I've overrun a couple of minutes. Would you bear with me 1 second?
Yes, of course.
Unless there's anything else.
Thank you, Mr. Westgate. We're very grateful. Mr. Rutledge.
Thank you, my lord. Excuse me. Thank you, my lord. I have a list which runs to 4 items for reply. The first is some general remarks arising out of the respondent's case. The second is to pick up on some of Mr. Westgate's submissions, in particular the approach to reasonable steps. Thirdly, to address, I suspect, as briefly as Mr. Westgate introduced them, the additional grounds for upholding, and fourthly, some additional points for the court to consider. The respondent's headline case, as they put it, is that Croydon is inviting this court to rewrite the duty in section 1932. That's not the case. On the contrary, it's the respondent, we say, who's seeking to redefine it. To redefine it as a duty that is to be formed in each case without reference to resources, without reference to policy, and without reference to the fact that the local authority owes duties to other applicants. One only has to contemplate how that test would operate in practice to know it's unworkable and highly unlikely that Parliament would ever intend such a scheme, especially in a statute of this nature. And I spent time yesterday going through the background, the policy background and the purposes of this legislation. The long title to this Act is an Act to make provision for homelessness. So it's not just a bilateral affair between the local authority and an individual. Your Lordships have my submissions on that.
Well, Parliament can't have intended that when the court's found that the local authority is in breach of its duty, the court then embarks on some evaluation of the competing claims of other people and the resources of the council and so on.
Well, Lord, I'm going to...
Normal order is just you just comply.
Lord, yes, I'm going to address that on reasonable steps submission. I understand the Lord's point. Nothing I say detracts from the acceptance yesterday that it's a duty, it's an immediate duty, and it's non-deferrable. But the Lord has my submission that it's a duty not to be exercised in this vacuum, but with an awareness that there's a need to provide a service generally.
But is this submission directed to the content of the duty or to the enforcement of the duty as a matter of discretion by the court? I would understand it if it were directed to the content of the duty.
Yes.
It's more difficult at a discretionary stage.
Well, Lord, I'll come on to that, but we say the content of the duty is to provide for an individual, a service for an individual, but not to lose sight of the fact that there is a service generally. It's Lord Justice Lewison's point about concurrent duties. But we say that that's not a tenable construction of this Act, that what the respondent's construction does is to ignore the wider public dimension of the problem of homelessness and turns it into a bilateral affair. It simply fails to grapple with the reality that the local authority is faced with multiple claims. And one can only speculate with the position where the local authority receives an application on a Tuesday, accepts the duty. On my friend's analysis, everything's got to be focused on that applicant, irrespective of the fact that the day before, on the Monday, the local authority accepted duty to 10 other applicants. It's simply unworkable, we say. And the idea of excluding resources generally from this, that runs into difficulty. We had discussion yesterday about the problem. What is the basis upon which the court will delay or suspend the operation of the order? If the court's satisfied that the local authority hasn't done enough and it makes an order but feels that there's a need to postpone that, what's the basis of that if it's not a recognition that the resources may impact on the local authority's ability to perform its duty. I mean, one can consider all sorts of cases. There may be an example where the local authority says to the court, we simply cannot provide anything at all in the next month. We've got nothing. But we then have nomination rights coming into force with a housing association. There's suitable accommodation there. And we will give a direct offer to the claimant of one of those properties. Now, that's a plea to a lack of resources, and the court is, depending on the circumstances, but quite likely in my submission, to say, well, we'll make an order, but we'll not have it come into effect until that time. That's not administrative convenience or just some sort of deal between the court and the litigant. That's an acknowledgement, recognition that resources come into play. Lords, in our respectful submission, this case ultimately concerns the interpretation of the duty and whether that duty, in its statutory and social context that we developed, whether that permits consideration of resources, the content of the duty.
It doesn't concern that. The appeal you probably should have brought is saying that the duty is too onerous, unworkable. You can't have an immediate, unqualified obligation because in reality it can't be fulfilled. But as you're not making that point, you can't, as it were, claw it back at the remedy stage by saying there is the duty, but the answer is for the court not to enforce it.
Lord, yes. Lord, I made the submission yesterday that the way to construe the duty, section 1932, is to read it in conjunction with section 2061, because what the court is being asked to do is to compel the local authority to perform its duty. It's not about the incidence of duty. That's not our case. That was Birmingham's case. It's not Croydon's case. But the duty exists.
But Croydon has accepted there's a breach of the
Exactly. But then, my lord, the question comes to, having accepted the duty, what must Croydon do to perform it? The claimant isn't coming to the court for a declaration, the acceptance of duty. The claimant's coming to the court for a mandatory order to compel compliance. That brings 2061 into play. Now, 2061 gives three options, mandatory alternatives for the local authority to perform its duty, and reasonable steps relates to those options. That's the content of the argument. The claimant will say, well, you haven't looked into the private sector. That's an option. You haven't looked at your own stock. That's a different option. So we are very much in the area of 2061, and that gives discretion between they've got to comply with the duty, but how they comply with it brings in an element of discretion, and that's discretion that can be informed and will be informed by resources. This is a good example of this case. We cannot access wheelchair adapted or adaptable properties in the private sector. It just doesn't happen. Landlords won't allow it. That rules out one possibility under 206. Therefore, we're trying to find a solution in our own stock. That's a different option. That's a weighing up of resources. So the submission is you cannot disassociate the performance of the duty that's owed with the resources of the local authority. And then we're into the area, per Lord Brown Wilkinson in Tandy, that if you've got statutory options, if you've got different ways of performing your duty, then resources are relevant. That's Lord Brown Wilkinson at page 1604 of the bundle, and it's page 747B of the law report. The local authority entitled to have regard to resources between, in choosing between different ways of securing suitable accommodation. That's putting it into the context of this case. So we say that when one's looking at the performance of the duty, which is what the mandatory order is going to relate to, the local authority is juggling resources. And the submission is this: if that's the exercise the local authority has to do, then for the court to ignore resources amounts to the court enforcing a different form of statutory duty. The court is being asked to compel performance. The court must therefore enforce the duty that Parliament has imposed on the local authority. Now, Lord, I'm going to address, when we look at my friend's reasonable steps, the practicalities of this, because we recognise, and I said this yesterday, it could get out of hand if not properly controlled. That's not Croydon's case. It's got to be a very controlled, and I'll address my Lord Legate's point about evidence in a moment. But the submission is that this is a duty, the performance of which involves consideration and a balancing of resources by the local authority. And if the court doesn't acknowledge that, accept that, it's not compelling performance of the right duty. It's performing something else. So the challenge, in my respectful submission in this sort of case, is to identify the correct approach of the court in those circumstances. Because if that's the task for the local authority, then it's only fair the court should expect it to perform that task and not another task. But on the other hand, one can see that an ill-disciplined approach would allow the matter to expand outside the confines of the case and get into an inquiry about how the local authority spends its money and what it doesn't. That's not our case, and I'll address that in a moment. So that, my Lord, is the headline submission. Can I then come on to what my friend says about the reasonable steps? He says, first of all, reasonable steps is a decision for the court and not the local authority. Can I just say that in exchange with Lord Sales yesterday, I made the submission that reasonable steps is principally a matter for the local authority, subject to the supervisory power of the court. And can I just say that having reflected on that overnight and taken instructions from that, we see that may not be the most attractive way of presenting reasonable steps, bearing in mind we're dealing with a breach of a statutory duty. On the other hand, an approach whereby the court decides in every case what the steps is going to be and then expects evidence or proof that they've been taken is a little too rigid and doesn't take into account local variations, in our respectful submission. So, looking to achieve a workable solution, we submit that it would be right that the court should take control and decide for itself what is reasonable, but it should take into account any evidence that the local authority lays before it as to local difficulties. So if the local authority has a particular problem, say for example, a local disaster or a influx of homeless persons from a particular area or whatever, that sort of problem, that's something the court should have regard to. But we do accept on reflection and after discussion that the court will want to have more exercise over the reasonableness of the steps than a simple Pulhofer compliant inquiry would allow. I hope that's helpful, and that addresses my friend's first point. My friend then says his second point of reasonable steps, it must always be reasonable to expect a local authority to exercise a full range of its powers. Well, in my submission, that's simply unrealistic. the default position, it is that it must exercise full range of its powers, certainly in the context of where the court's deprived of any opportunity to look at resources. And linked to that, he says that expenditure of the powers will always be reasonable. Again, respectfully, that's wholly unrealistic, especially if the local authority is able to put focused evidence before the court, that is simply not feasible. And I'll come on to impossibility in a moment. My friend placed emphasis in relation to that item on the fact that the homelessness legislation protects disabled persons. It's absolutely right, it does. But so too does the other legislation, Part 6. One of the grounds of categories of reasonable preference is persons with disabilities. And there are some very, very serious cases, and Croydon put some in evidence in this case. Very serious cases which are not statutory homeless cases, but are nonetheless priority, and whose rights would be overridden, or expectations would be completely overridden, if my friend's approach were adopted. Next, my friend says that local authority must show in sufficient detail what it has done or not done. Well, I don't think we disagree with that. I made the submission yesterday that it's fair to expect the local authority to lay the evidence, as this local authority has here, as to what it's done. The court can't understand the context in which reasonable steps have been taken unless it's got evidence. We accept that, no difficulty at all, and they've gone to detail in this case to do that, and against that evidence the court will make its assessment, so that's not controversial. Then the next point, the local authority must focus on what the claimant needs, and references to general pressures are not good enough. They might be, depending on the circumstances, but we certainly don't dissent from the proposition that the focus must be on the claimant, but, subject to my point about the wider purpose. And without going through it now, it's not time, there was, in his very lengthy, detailed witness statement, Mr. Beasley did look specifically at the needs of him and her household, and what steps have been taken, and such like. Then my friend says the court's got to have an explanation which extends to planning what can be done. Again, I don't think we dissent from that. Subject to this point, and I think this is where we're at risk with my friend's approach of getting out of hand, because his next point is local authority must show what it has done to address deficiencies. Here we are at risk of expanding the inquiry far beyond enforcement of this particular duty into a general inquiry as to the resources and allocation of them in the particular local authority, and that's something this court should be very careful to avoid in our respectful submission, which is why we say, and the approach that we respectfully commend, is the all reasonable steps approach, with the court assessing for itself the reasonableness, but having the ability to consider the evidence that the local authority puts before it as to any local difficulties, and the reasonableness to be considered in that context. And we further endorse respectfully Lord Justice Lewis's conclusion on that if the local authority can satisfy the court, I'm not accepting reversal, burden of proof, but in practical terms can satisfy the court that it has taken all reasonable steps, then importantly that is a very powerful indication that the local authority would not be able to comply with a mandatory order. And as a matter of principle, the court should not make a mandatory order against the local authority. It should not set up a defendant against clear and obvious failure. And the last point my friend says, the court must look at all the steps the local authority must take rather than all reasonable steps. Well, Lord, again, that could get out of hand. How can one say what steps, how many steps there are in a particular case? It's got to be... I'm going to get into the pleading point because that's actually quite important here, because a friend has said that...
Just on the pleading point, do we actually have the pleadings, the claim form and the statement of grounds?
We don't in the bundle, no.
Well, can they be supplied anyway?
Yes, they can be supplied if required, or whatever.
If you're making the pleading point, then they have to be supplied, really.
It's a general point, my Lord, yes. It's a general point, and I set it out briefly yesterday. I made the submission that there's no formal reversal of the burden of proof here, although it's readily accepted the local authority...
I'm sorry, in respect of what? Do you not accept that it's for the respondent to explain why relief shouldn't issue?
Yes, the local authority, when the local authority is in breach of duty, yes, and the question for the court is whether it should grant a mandatory order enforcing that duty, the local authority must lay evidence before the court on which the court can assess whether it's taken reasonable steps. That's the first position.
Yes.
But that doesn't mean that the claimant can simply come to court with no grounds and say, well, proved that you've established.
I mean, a claimant in the claim form in judicial review proceedings would state the relief that he or she was seeking and wouldn't deal with an argument that discretion shouldn't result in the issuing of the order unless and until it's raised.
Well, the Lord...
In the real world, these arguments about whether to issue a mandatory order or a quashing order or whatever the case may be arise at the end of the case. In my experience, at least, they're not subject to pleadings at all.
It didn't arise in this case, my Lord. It arose in this case because there was no dispute that there was a breach. And so the claim...
You put in your evidence and then the claimant's entitled to say it's not good enough.
No, well,
no pleadings needed for that.
No, respectfully, the way to deal with it is proper compliance with the pre-action protocol procedure. What the claimant should do is to say to the local authority, do you accept that you're in breach or not? If not, then you've got to fight over the incidence of the duty. If they accept they are, then the pre-action protocol should flush out the steps that the local authority has taken. And if the claimant thinks they are deficient, then the claimant pleads grounds.
Is that what happened here?
Well, it did and it didn't. There were allegations of course, if the case was ground one, there's a breach, therefore we need a mandatory order. But the procedural rigour that is necessary in this case, as any other, we say, is for the claimant to set out what they say based on protocol response, the local authority has failed to do, and then the local authority can put its evidence in. Otherwise, it becomes a trap for the local authority. Doesn't it? It goes to court.
I thought we were told that the local authority hadn't put in pre-action protocol response.
Well, Lord, there's a long history of that, and that's partly right. There were some letters unanswered, but I think there were one or two that were. But I'm addressing the position, my Lord.
Well, how can we assess what you're telling us now without seeing the documentation?
I don't want to draw the court into that unless
right.
it's...
Well, let's suppose that there was no pre-action protocol response from the local authority.
There was...
What happens then?
There was some, I think, but not...
But you're not showing us it?
No, well, it's not in evidence, or it's not before the court.
Right, so let's assume there was none. What then happens?
Well, in that situation, I accept... I'm addressing these remarks because I anticipate, indeed, we would respectfully invite the court, whatever the outcome of the appeal, to consider how cases of this type ought to be presented. If this court is minded, for example, to adopt the all reasonable steps approach, then clearly it would be helpful to say so, and it would be helpful to explain the position of the court, the standpoint of the court in relation to the deference point I've made.
What's very unappealing is for the standard case to be that where the authority admits that it's in breach, that's not the end of the dispute, that's really just the beginning of it. And one then has a whole battery of evidence about what it hasn't done, criticisms that evidence doesn't cover all the points,
yeah, but if
and uphill and down dale.
Well,
we can't tolerate a system like that where the question is simply whether the court exercises its discretion to enforce make an order enforcing the duty or it doesn't.
yes, but then the court can't exercise the discretion unless it's got the evidence before it. That's the point.
What's being put against you is the onus is on the council to bring forward evidence which will persuade the court, and it hasn't done so. So is there anything more that a claimant needs to do? It's pleaded breach of the duty, which has been admitted. Ordinarily, relief would follow in relation to that, and it would be mandatory relief since it's an individualised duty owed to this claimant, unless the defendant can bring forward a case to dissuade the court from following that usual course, which hasn't happened.
My Lord, the submission is that firstly that's not in accordance with the rules. The rules require a claimant to plead grounds. Those grounds the local authority defendant can then address in evidence, and the court can then make the determination. Respectfully, it would be quite unfair on the local authority to come to court, putting evidence in without knowing what points are likely to be taken against it. I mean, we haven't looked at it, but there's a case in our bundle called Bell and Lambeth, which was a post-Sel Cundy case, where the local authority put in very detailed evidence about the steps it had taken. For example, that it had approached 11 other local authorities under Section 213 for assistance in accommodating a family with very high needs. And the judge held ultimately that wasn't good enough. They should have been approached other local authorities. It makes it very difficult for local authorities to defend this sort of claim. If they have taken all reasonable steps, they ought to be able to present that to the case, to the court.
In which pleading would this be set out by a claimant? So the process is for a claim form, and a claimant wouldn't be at that stage considering arguments that haven't yet been raised. Then there's the short form response, and then detailed grounds with evidence. Yes. So when is this pleading to take place within the scheme of the relevant rules?
Well, the relevant rules require the claimant to put the grounds in the claim form. As I said, the way it should work, we're looking now, as I understand it, at good practice and guidance. The claimant should ascertain whether the local authority accepts or denies there's a breach, and should ascertain from the local authority the steps it has taken. I accept Lord Lorteo's point. If they don't do that, there may be a different consequence. But if they do that, the claimant should then plead the grounds. The respondent, the local authority defendant, will then put evidence in, and the court will then be able to assess accordingly. What can't be allowed to happen in our respectful submission is the claimant simply to put in a one-line claim form, you're in breach, and for the local authority to come to court and not know the target that it has to meet in terms of defending itself.
It's not defending itself. It's trying to argue that it shouldn't have to do what, on the face of it, it's bound to do. The claimant has won, and now it's for the local authority to explain, falling on its knees, why the court shouldn't make an order. It's not for the claimant to have to set out in the claim form grounds why the court should make the normal order. and why the local authority's anticipated response to that isn't sufficient.
Well, my Lord, I've put the position, the local authority, that it needs to know the case it has to meet. That's fundamental. I don't think I can put it any other way. Just looking at the time.
I mean, I can see that if the local authority admits the breach of duty,
Yes.
And either in its pleadings or ideally in pre-action correspondence, says, notwithstanding breach of duty, here are 8 reasons why we will be inviting the court not to make a mandatory order, that issue may then be sufficiently joined that there would be perhaps some sort of onus on the claimant to say, well, we don't accept that, or we have points we want to make against that, but none of that seems to have happened here.
Well, that's well, there was some response to the pre-action protocol, not much. I understand that. It's difficult for me to make submissions when your lordships don't have the papers. What I'm addressing is my friend's submissions on reasonable steps, anticipating that this court will take the opportunity it has to give some guidance without adding to the burden as to how cases of this nature are to be presented. And in my respectful submission, these are fairly logical, fair and conventional steps in litigation between 2 parties. Simply ensures fairness to the local authority in coming to court and knowing what the target it's got to meet. It's simply the submission. Can I just pick up on a few points in my friend's presentation? I just want to mention, get out of the way before I draw submission to a close. My friend invited the court to look at the statutory background to the 1996 Act in support of what he described as the balance that Parliament has struck between Part 6 and 7, and invited the court to look at the excerpt from Arden and Bates' Homelessness and Allocations. Can I just, I don't have the time to go there now, but can I invite your lordship just to pick up at 1.78 of that extract, which talks about this is the white paper to the 1996 Act, and it talks about the principal policy change affected by that Act, quote, to minimise the priority call on homeless people on local authority stock, close quote. And it says that may be addressed under 2 heads, principal homelessness changes and allocation changes. Well, essentially, on the balance point, we saw this yesterday, that Part 6 was firmed up. The reasonable preference groups were strengthened so that the local authority can, for example, give additional preference on reasons such as local connection, not connected with homelessness. So Part 6 has been firmed up. And homelessness changes have included an emphasis more on the private rented sector than on local authorities' own stock. And one just looks at the statute of the amendments to see how that's happened. We looked at the 1977 Act, and the list of things the local authority could do was very short compared with our modern Act, 193, when there are a number of things, including assured tenancy for the private landlord, a PRSO, matters of that nature. So the policy, the actual policy change affected by the legislation has been to try to, as it says here, minimise the priority call on homeless people on local authority stock to redress this balance. And that's a point we say supports our submissions, in particular on ground 2. Hendy, I don't think I have time to make but the short point on Hendy, insofar as it's necessary to deal with that, was that the complaint, which I think was unchallenged, was that the temporary accommodation was unsuitable. It was short-term, short-fix accommodation, I think the term was. That case proceeded on the basis that there was a breach, extant breach of Section 39. So Hendy was, in our submission, a case on breach of statutory duty, and the judgments in relation to mandamus, as it was, should be read in that light. My friend made submissions about impossibility. There are two ways of looking at impossibility. There's in the traditional Bristol Corporation sense, and there's in the sense that Lady Justice Arden, she was perhaps talked about it in Aways at para 65, page 1225, what she said, in effect, an impossible situation. So, your Lordships may see the submission recorded in the judgments below was that impossibility doesn't actually set that higher hurdle, that it means legal and practical impossibility. So, and there is a potential flaw, we say, in the respondent's analysis, because where is the line between, on their case, once it's impossible, then everything's in, everything about it, resources comes in. But where do you draw the line in practical terms? That's a difficulty. So if you have a rule that says resources are completely out of the picture, except where it's impossible, where do you draw that line? And that would be unworkable in our respectful submission. The proper approach is to accept that this legislation requires local authorities to make tough decisions about resources, and therefore the court, in compelling performance of that duty, must also have regard to that difficulty in the way that I have submitted, in that more supervisory plus, Pulhofer plus role of the court. Lord, I'm just going to deal briefly with the additional points. Your Lordship had our supplementary case, and we say none of these, respectfully, is a point for the Supreme Court, and that it is, apart from anything else, unfair on Croydon for points of this nature to be taken before a court against which we have no right of appeal. They are points which ought to have been taken below, and in some cases were, but not pursued. And in any event, for the reasons we set out, and you don't have the time to go through them, but we have put that note in and cross-reference to the evidence, have no merit whatsoever. It does raise, it may be that this is not a case for your Lordships to consider it, and I certainly don't want to add to the burden for this court, but it does raise a question about what Rule 25(1) means, allowing respondents for an appeal in the Supreme Court to put in additional grounds. And that may be an argument or a discussion for another day. So, my Lord, can I just... a moment. I could just sum up our position on the various grounds. Ground one is in two parts. The part one is the question in principle whether resources are relevant. to the performance of the duty. And your lordships have my submissions on that. They are, as a matter of statutory construction, they are relevant to the performance of the duty. The question then arises, what did the Court of Appeal decide? Did the court accept that proposition, but find nonetheless that the deputy judge fell into error or not? And although we accept that there are passages in Lord Justice Lewis's judgment where he accepts or appears to accept that resources are relevant, in particular 131, 134, 137 and 141, but equally there are passages where he seems to say they're irrelevant. 137, 141 and 152. But it does respectfully beg the question, if they are relevant, why Croydon lost the appeal on that ground. If it comes back to the reference to finite resources or the overspend in para 81.5, the court has my submissions on that. They need to be read closely in connection with the submissions that were made to the deputy judge, which are set out in the judgment. Paragraph 57, 56, forgive me. The submission before the deputy judge was that the question of the local authority's resources was relevant to relief and that the claimant had not challenged the allocation of resources to housing by the defendant. That was the submission. And 81.5 needs to be read in the context of that, where the deputy judge talks about resources available to the defendant to discharge its statutory duties under Part 6 and 7. So if one actually looks at that closely, what one sees is you get the reference to the £67 million projected overspend as general information, but then specifically in relation to Part 6 and 7, that's the waiting list and the homelessness departments, specifically a finding about the resources available, and that's available in the current year, hence the reference to DOM. So,
from that, I mean, how could that tell you anything that helps you decide how to exercise your discretion? You're always going to be told that the local authority doesn't have enough money to meet all the demands on it. How is that a reason not to exercise the discretion?
Well, my Lord, I made the submission yesterday that this is against the background of a case where it's been put forward that the local authority should buy a property for the claimant, and the 67 million came in. It was simply a general remark to say there's a general financial pressure on this local authority. We're not going to be able to achieve that. That's as far as it goes. We simply say that's not an error of law contained in that judgment, that paragraph. This is one of a number of 8 reasons the deputy judge gave for exercising his discretion. He placed particular emphasis on the first reason, which are the conditions in the property and the impact on the claimant. So we say on the second limb of ground 1, and I'll be quick now, my Lord, I'm noticed the time. The second ground of 1, there simply wasn't a sufficient error of law. With the Court of Appeal, the Degnan case applies, there's got to be an error of principle interfering with the exercise of discretion by the judge. And he didn't get that stage. So we say, firstly, we were right on resources, whether the court found it or not. Secondly, there's no error of law in that judgment sufficient to allow the appeal. And on ground 2, your lordships have our submissions on that. We made 4 points on ground 2. The first was a pleading point. We provided to the court today the decision of Mrs. Justice Lang in the Wingfield and Canterbury case, and this is the case that's referred to in the footnote of the helpful guidance, the administrative court guidance on replies. And as Mr. Westgate has already explained, there her ladyship said that first, it is no provision for reply, secondly, grounds need to be pleaded, and thirdly, there ought to be a formal application. So there is a clear procedure. Let's put that in. That was our first point. Our second point on ground 2 is the deference point, and we do emphasise that respectfully. It's simply not the business of the court to decide whether the local authority should be offering one type of tenancy or another. And then we say there was no the step the Court of Appeal identified would be irrational, administratively unworkable, and Mr. Westgate's really addressed that in any detail. And fourthly, even if we're wrong about all those matters, it was addressed in the evidence. Even if it hadn't been pleaded, Mr. Beasley had in fact addressed them. And this is something that pretty much came up in the course of discussion in the Court of Appeal. That goes back to my original submissions about pleading. It's not the way that it should be, it should happen. It's simply unfair on the local authority. May I have a moment?
Yes, of course.
Oh, yes, can you just... 456, what's in here, isn't it? Yeah. 456. Oh. Yes, I'm grateful to my friend. Can I just, the Lord Legate asked about specific evidence, and this might be a helpful illustration, actually, if we're going back to our discussion. If my lords could take up the appeal bundle at page 456. And there we have, this is an exhibit to Mr. Beasley's witness statement, and there we have 4 anonymised case studies put before the court of actual cases, and cases 1 and 3 are waiting lists, priority band 1. These are all competitors in one way or another, and 2 and 4 statutory home lists. So the local authority is furnishing the court here with specific evidence of people who will be impacted on by the court making an order. Your Lordship's had all our submissions about spreadsheets and general evidence of debt. That's not our case. Our case is the local authority, if it knows the target it has to meet, can put evidence in of this nature, and so the court can then judge for itself the impact of the order it makes.
Well, we have that evidence. We can look at it.
Yes.
I don't think there are any questions. Mr. Beasley, we're grateful to you for your submission. Mr. Westgate, we're grateful to you and to all counsel in the case, and to those sitting behind you for the preparation of the bundles. We will take time to consider our decision on the matter, this important matter, I should say. There is one... Sorry, Mr.
No, it rises out of the point made by my Lord Sales about the pleadings and the documents that the court may want us to provide. We obviously can provide the pleadings. There was a reply in this case, it would include that. But there's also been discussion about the pre-action protocol letters. We don't want to besiege the court with hours and hours of documents. But first question is, would the court find it to help for us to put in the pleadings? And secondly, should that extend to pre-action protocols correspondence, or perhaps, if we can agree, pre-action protocols correspondence to go in?
Might as well have it if we don't want to read.
We'd better have them.
We'll do that.
Thank you very much. There is one further matter I should mention before the court rises. and that is that Mr. Robert Greenberg, who is a member of the staff at the Supreme Court Registry, is retiring today. Mr. Greenberg is present in court, I hope. And because he's been looking after us through this hearing. Mr. Greenberg joined the staff of the Appellate Committee of the House of Lords shortly before the creation of the Supreme Court, having previously been in the Court of Appeal. He was therefore present at the birth of the Supreme Court, and he's been a great strength to this court and to the Judicial Committee of the Privy Council over the last 15 years. The members of the Supreme Court are deeply grateful to him for his support. He's been a truly outstanding colleague, and we all wish him a long and happy retirement. Very much.